Good afternoon, everyone, and welcome to the HGAR webinar on the NAR settlement, which will begin right now with our special guest host, Brian Levine, our general counsel for the association. Brian, it is all yours.
Thank you, Gary. Much appreciated. Okay. Good morning, everybody. We're here for the webinar series, Understanding the NAR Settlement. I'm going to share my screen with everybody. You know, if everybody can see that okay. Gary, did everybody see that okay?
Yes, if you just want to put it into a format.
There we go. Fantastic. All right. Good morning, everyone. So here we go. We've got a lot to cover today. We're going to go over the settlements, what it means to you. We're going to go over the HGAR forms. We're going to go over the NAR forms. We're going to discuss the differences between the two. And then at the end, if we have time remaining, we're going to do some Q&A. So with no further ado, I'm going to get right into this. First of all, I have to give you this antitrust statement notice. Obviously, we're a not-for-profit. We are not suggesting that you participate in any kind of price fixing, any numbers or terms that I give to you today, whether it be a percentage. I'm not recommending that you utilize those percentage. I'm using those only for example purposes only. And of course, anything that relates to antitrust, we oppose. Again, a disclaimer, I am general counsel for the association. That means I'm the counsel for the association. It means I'm not your attorney. The documents we're going to look at today, they are model documents. You are free to modify them and make changes. I recommend that you speak with your legal counsel before you make any business decisions or you choose to modify these documents. So jumping right into it, let's get into the NAR settlement. Back in March, NAR proposed a settlement that would end all the homeowner litigation that was going on at the time, in addition to about 26, 29 other copycat claims. This did not resolve the home buyer litigation that is still ongoing, but hopefully this is going to wrap all of this up for us. It's going to be applied globally, and it applies to all national claims. The interesting part is HGAR, NAR, one key. We were not named in any of the litigation, but this settlement encompasses and protects all of us as long as we are NAR members from any kind of claims. So I say it's a proposed litigation, even though back in March we entered into it and NAR is now implementing the changes. We have to wait till November 26th. That's the tentative date that the court is going to approve this. We have had some indications that the court is willing to move forward with this. So we are hopeful that come November 26th, this will be put to bed. In addition, NAR continues to deny any wrongdoing by entering the settlement agreement. We are not admitting that we did anything wrong. We did agree to make a payment. That payment is $418 million. It's going to be paid over the period of 4 years. The good news for us is that dues for 2024 and 2025 will not go up. So, what are the rules? The rule changes are really simple. There are only two things that are going to be done. The first is we prohibit offers of cooperating compensation on the MLS. And we're going to require written buyer agreements. So as it all boils down, it's just those two things. Now, those two things have some impact, and there are some details that we're going to talk about today. So first thing is, as you may or may not be aware, as of August 8th and effective August 17th, no offers of compensation are going to be permitted on the MLS. This took effect for one key back in August 8th. And if you look now, you will see no offers of cooperating compensation on any source. Buyer agent, broker agent, sub-agent, rentals. And you cannot offer cooperating compensation on the MLS. In addition to not putting cooperating compensation on the MLS, you cannot utilize any MLS facilitated mechanism. So, for example, showing time. You cannot put offers of cooperating compensation on showing time. But in addition to, although the litigation only related to residential properties, one key has taken the steps through NAR in the direction of NAR to prohibit any form of cooperating compensation. So you will not see cooperating compensation for residential properties, any commercial property, land, or rentals that are going on to One Key MLS. You cannot make any reference to cooperating compensation in your agent remarks or in your public remarks. But that doesn't mean that you cannot offer cooperating compensation. You are free to offer cooperating compensation. In fact, you can put a link on the MLS that takes you directly to your broker page or your agent page, where you can identify all your properties and indicate if there is any cooperating compensation. But there's a lot more that you can do as well. You can put cooperating compensation on your broker website, as I said. You can put it on signs, riders, flyers. You can advertise it on social media. You can put it on a billboard. And probably more often than not, you're going to get a lot of phone calls, a lot of texts from people inquiring if there's cooperating compensation. In addition, with the removal of cooperating compensation on the MLS, there is an addition, and that is that seller's concession is now being placed on the MLS. So quickly, let's talk about seller concessions. This is a new field. Seller concession is going to have a drop-down box that's going to say, is your seller offering seller concessions? Yes or no. If the answer is no, that's fine. But if the answer is yes, there'll be another drop-down box, and that will identify a specific dollar amount. Now, it's not required to put anything in there, but you are free to put something in there at the direction of your client. The challenge is seller concessions cannot be limited or conditioned upon the retention or payment to a cooperating broker, buyer broker, or other buyer representative. So it can't be connected directly to the requirement that it be utilized for cooperating compensation. Again, if you put a number, a dollar sign out there that says my client is considering paying this amount, they're not required to pay that amount. And that amount is fully negotiable. And ultimately, if there is a seller concession, that will be memorialized in a purchase and sale agreement or another form of memorializing it. That will be a contract. Here's the big kicker. Do not use the seller concession as a workaround. They are watching Department of Justice, the MLS, HGAR, the attorneys in the litigation. And if they start seeing seller's concession magically amounting to, say, 2% or 3%, they're going to start saying, this is a workaround. And you are utilizing seller concessions as a way of marketing cooperating compensation. That can pull you out of the settlement agreement, and it could expose your brokerage and yourself to litigation. So the new forms we're going to go over today, they're forms from NAR. This is the website where you can find the legal forms. You'll also have a guidance in there on how to fill out the forms. Also, there are new forms on HGAR. They're located on our member portal under, where of all things, documents. So let's talk about the exclusive right to sell agreement. There are some new rules. Exclusive right to sell has to be conspicuously noticed. That cooperating compensation is not set by law and is fully negotiable. As we all know, cooperating compensation can be something, it can be nothing, and it must be authorized by the seller. Now, there are options to pay commissions. My apologies. A seller can pay the commissions directly to the cooperating broker. The listing broker can be authorized to pay the cooperating broker. There can be no cooperating compensation at all. Plus, we're going to go over a new section with regard to dual agency and unrepresented buyers. In the past, it was common practice to have a pool of money that was given to the listing side, and if there was cooperating compensation, they would give a portion of that out. Now, there is no pool of money, and each part is split up. So listing side will have its compensation. If there's cooperating compensation, it'll be offered out. And therefore, we need to account for what's going to happen in the event of dual agency. So let's take a look at NYSAR's exclusive right to sell. What you're going to see is, first of all, this is the listing broker compensation. This provision says that it's fully negotiable, and the parties initial that, yep, we understand it is fully negotiable and it's not mandated by law. And then it goes into the compensation to the listing agent. That can be a percentage, it can be a dollar amount. It is not both, it has to be one or the other. And that is compensation for the listing broker only. Then it talks about dual agency. As I said before, in dual agency, there is one broker, and there is either one or two agents, one representing the seller, one representing the buyer, or it's one agent representing the seller and the buyer. Because you are handling both sides of the transaction, it is reasonable and appropriate to obtain a higher commission because you're doing that much more work. NYSAR originally had all these provisions lumped into one sum, but they are expanding it to make each one individual. So you will see this is where you would place your change for direct dual agency. It'll be a percentage or it'll be a dollar amount. If it's dual agency with designation, this is where you would put the dollar amount or the percentage. And if it's an unrepresented buyer, this is where you would put the dollar amount or the percentage. You could have all three of these filled out with different numbers. You could have all three of these filled out with the same numbers. That is for you and your seller to negotiate. Now, we've talked about the listing side compensation and the dual agency compensation. Now we're going to look at NYSAR's cooperating compensation provision. So first up, is your client, your seller, offering out cooperating compensation? If they're not, you sign and initial this first part. However, if they are offering out cooperating compensation, then you'll have to check one of these boxes. Either the seller is offering out directly to the cooperating broker, or the seller is authorizing the listing broker to offer it out to the cooperating broker. If so, we need to decide who's it going to and how much is being offered. Keep in mind, cooperating compensation can be provided to a buyer agent, a broker agent, or a sub-agent. Again, it can be a percentage or a dollar amount. It should not be both. This is what the provision looks like for seller's concession. It is Article 10. It says that the seller agrees to a fixed amount or a percentage in the purchase price at closing. That's going to go towards the buyer's closing costs, etc. If they're offering out a seller's concession, you will both initial it here. Keep in mind, there is no place to put in a dollar amount. So if there is a specific dollar amount, that will need to be memorialized somewhere else. So that's NYSAR's right to sell agreement. Now we're going to look at HGAR's right to sell agreement. Now, keep in mind, we're going to go over a couple of things here. We're going to go over the addendum to the exclusive right to sell. We're going to go take a look at the actual exclusive right to sell itself. And there's also a rental form. Both of these, the exclusive right to sell and the rental form, are very, very similar to each other. So I'm going to handle them in one lump. So the first thing we're going to look at is the addendum. Hopefully, you've had this addendum filled out already. As I said before, the requirement was August 8th that the changes were going to go into one key MLS. And by August 17th, you had to have your documents updated and amended. So if you did not want to have your client fill out an exclusive right to sell agreement, you could have them fill out this addendum. So this addendum incorporates all the important parts that fall under the NAR settlement agreement. And it references first the date and the expiration date of the original document, the original exclusive right to sell, and it identifies the property. So that is a reference back to the original listing agreement. And then it makes changes to it. First, it has that special language that cooperating compensation is fully negotiable, and everybody has to initial. It then goes on to say, and for lack of a better term, it says, look, when we originally signed up this listing agreement, I was going to offer cooperating compensation out on the MLS if that's what was agreed to. However, going forward, we are no longer offering out cooperating compensation on the MLS, but I will utilize other avenues to offer out cooperating compensation. And the final provision is, this confirms that cooperating compensation is going to continue to be offered out, and the parties again initial. So this is the exclusive right to sell agreement. It is nearly identical to the exclusive right to rent, except instead of homeowner, it is landlord. Instead of buyer, it is tenant, but the language is pretty much the same. First up, that fully negotiable language that everybody has to initial. After that, we go into the listing compensation only. For HGAR, you identify either a dollar amount or a percentage. Understand, HGAR's forms provide only for listing broker compensation. There is no provision for cooperating compensation. That doesn't mean you can't have cooperating compensation, but you'll need to memorialize that elsewhere. Use the NAR form, modify these forms with the guidance of your attorney or otherwise. Keep in mind, if you utilize different forms or if you modify these forms, make sure that they comply with the NAR settlement agreement and New York state law. It then goes into dual agency. This is where you identify that in the event that you are a dual agent, a designated sales agent, or an unrepresented buyer, it is deemed appropriate that you should get an increased commission. You can set that forth either as a dollar amount or as a percentage. We have a provision for a seller's concession. The first one is if there is no seller concession. The second one is if there is a seller concession. Obviously, you will only initial one. So that covers our exclusive right to sell agreements. The rental agreement is pretty much identical to the exclusive right to sell agreement. So now we're going to take a look at the written buyer agreements. There are some requirements. First of all, you are required to have a written buyer agreement when you begin working with a buyer and prior to touring a property. So that means that buyer needs to be your client. You need to be working with them. What it doesn't mean is if a buyer shows up at an open house and wants to see a property, that you need to sign them up with a buyer agreement. That is not correct. The reasoning is you represent the seller. You are working at the open house. Therefore, that buyer comes in and they are a customer, not a client. You are free to show them the property. Again, the other part of it is you have to have this buyer agreement in place prior to touring a property. In addition to that caveat, you must state that all compensation is not set by law and freely negotiable. And we've talked about that previously. It has to be conspicuous, and you'll see that it is very conspicuous. It has to have an ascertainable amount. So it needs to be either a dollar amount or a percentage. It can't be whatever the seller is offering out, or a range between 2 and 3%, depending on the property. We have to be able to identify what the compensation is in legal parlance between the four corners of the document. And the last part is there's a cap. The buyer's agent cannot receive any amounts in excess of what is stated in the contract. So what kind of compensation agreements are there? Well, there's an exclusive. That's the one that many of us are familiar with. It is, I am your exclusive agent, and I am going to work with you for the next 3 months to find you a house. There's also the non-exclusive. That is basically saying, I'm going to work with you on this house, but you are free to work with any other agent. Now, what can you have in a buyer compensation agreement? Well, it can be a fixed fee, an hourly rate, a percentage, and as we'll see, there is even a provision for a retainer that can be worked down. As I noted before, it can be a one-time showing agreement. The scope of a buyer agreement can be geographic. It can be set for a period of time. It can even be for only showing those properties that are offering out cooperating compensation. I will warn you, if you do this, make sure you get this in writing, because otherwise it could be deemed steering and that you are only showing properties that are going to line your pockets with money. So make sure that if you are only showing properties that are offering out cooperating compensation, you get that in writing somewhere from your client. So first up, we're going to take the NAR written buyer agreement. There's two of them. There's an exclusive and there's a non-exclusive. They are both very, very similar with just one minor change in the non-exclusive. So we kind of work them together because there's a lot of forms we're going to go through today. So this is the provision. This is that provision where we talked about that it is fully negotiable. It then goes into the compensation, a dollar amount or a percentage. It then talks about that you're going to offset as a buyer's agent. You will seek to potentially offset what the buyer is going to be required to pay by potentially either through a seller's concession or through a cooperating compensation, offset those amounts. And you will do that, keeping in mind that if there's any remaining amounts, that buyer is on the hook for those remainder amounts. It also talks about dual agency. Remember, if a buyer and the broker agree to dual agency, whether it be designated or otherwise, the buyer is going to be responsible for the full amount of the compensation that is written under this buyer agreement. And any offers of cooperating compensation cannot be utilized. And here's the logic behind it. Cooperating compensation goes from one broker to another broker, thus the term cooperating. In the usual situation, a listing broker offers cooperating compensation to a buyer broker. However, when you are a dual agent, dual agency, there is only one broker. There is nobody to cooperate with. That means that the idea of cooperating compensation becomes a nullity. You cannot cooperate with yourself. That means that unless you filled out this dual agency provision, the buyer is on the hook for the full amount and it can't be offset. So strongly recommended you put those provisions in there for dual agency. And in the event that there is dual agency and the buyer is being compensated from the listing side, from his broker, then the parties can rewrite the contract, this buyer contract. Instead of saying whatever that percentage is, they can cross it out. They can put in the numbers, the number 0, and then they can initial it. Therefore, they rewrite the contract. It is still in effect, satisfying the NAR settlement rules, but the compensation is coming from the listing side, and the buyer isn't going to be obligated to pay anything under this contract. Here it identifies that you have a commission cap. You can't not receive more than what is identified. And here's that option for the retainer fee. So the non-exclusive for NAR is pretty much the exact same thing, fully negotiable, except for this. It identifies a list of properties that are going to be shown. It then goes into the compensation, the offset, the cap, and the retainer fee. And then attached to that non-exclusive is a list. This is where you put the properties you're going to show your client, and you should both best practice, initially. So what does HGAR's written buyer agreement look like? So again, there is an exclusive and a non-exclusive. They are both very, very similar, so we're going to work with them in tandem. The first part for HGAR is fully negotiable, and the parties need to initial and understand that it is fully negotiable. It then talks about the offset, that you're going to seek cooperating compensation or any kind of credits, and that you are capped, and that you will not retain any amounts that are in excess unless it's discussed and approved by your client. It then goes into the compensation amounts. Straightforward, paying a dollar amount or a percentage. It then goes into a deeper dive into dual agency and the compensation. So this provision here basically talks about how you're going to be offset. And what it says is that in the event of dual agency, whether it be a designated agent or otherwise, you are going to be responsible for compensating the broker the full amount unless it's otherwise negotiated and memorialized. So we talked about this before. Cooperating compensation cannot be shared. Therefore, under dual agency, that full amount would be owed to the broker unless it is changed or renegotiated. This is the acknowledgement that the amount that you receive is not going to go beyond a cap. And we provided the provision for a retainer. Now, deeper dive for us. Dual agency. In the event that there's dual agency, two things can happen. Well, technically, three things can happen. Number one, the parties can agree to enter into dual agency. Alternatively, if they do not want to enter into dual agency, one of two things has to happen. Either the listing agent has to dissolve his relationship with the seller, therefore permitting the buyer agent and the buyer broker to continue forward, or the buyer broker and the buyer need to dissolve their relationship, meaning that, number one, this deal, this contract becomes void, and you are no longer representing the buyer. And this is what results as dependent upon those decisions. If, for the transaction where the buyer chooses scenario B, which is the broker and the buyer dissolve their relationship, there is no compensation owed because this agreement is no longer in effect. If they choose scenario 1, then the broker and the buyer continue forward with their relationship, that the broker and the seller dissolve theirs, and any cooperating compensation that could have been paid can be accepted because we're no longer in dual agency, and any other arrangements can be resolved at that point in time because you are now no longer in dual agency. You are in single agency with the buyer being represented by the broker. All the parties need to understand these provisions. So let's say they want to go into dual agency. This is the provision that talks about dual agency and what happens. This is an explanation with relate to designated dual agency. And this is what the explanation is, which relates to the results of what happens if there is dual agency. And if you read, it says the buyer and the broker understand and agree that the broker is not entitled to cooperating compensation, and the broker is the sole broker in the transaction, and the buyer will be obligated to compensate the broker the full amount of the compensation. They cannot change this, and the broker cannot go back and say, hey, Mr. Seller, maybe you should pay me more because I'm doing both sides of the deal. If it hasn't been negotiated, that is not in the best interest of the client. So therefore, the broker cannot go back and try to renegotiate more money for themselves because they are a fiduciary and they should have planned ahead. That's why I reiterate that it's important that you have the dual agency provision filled out. So the non-exclusive, also very simple, identical to the exclusive, with the one exception is it identifies the parties and then it provides a list of the showings that you're going to go on. Again, all parties should initial this, so this becomes a part of the contract. So, buyer compensation requests. How does it work? Well, a couple ways. A request for the buyer compensation can be made a part of the offer. A request for seller concessions be made part of the offer. They can request both buyer compensation and a seller concession, or they can not ask for anything if they don't want. So with regard to compensation, Fannie Mae, Freddie Mac, FHA, they have this term, this principle is called interested party contributions. A seller is limited to how much they can contribute to the payment on the buy side. Because of the fact that cooperative compensation is customary and it's traditional, it is not subject to the cap. So that means that the seller is unlimited as to how much they can put forward towards that buyer buyer payments. Last note is that due to NAR's efforts, the VA temporarily lifted its ban on prohibiting applicants from using loans to pay commissions. That's a temporary lift, so they can utilize VA loans to pay commissions. That is not permanent. NAR is working on that, but that is to be seen. So let's take a look at those written buyer compensation agreements. Here's a situation, fact pattern. So what if the compensation is capped and the seller is offering more? I will throw out a fictitious number. This is not to be taken any way as what would be required or suggested. But let's say on the buy side, it is 2%. On the listing side, they're offering out 3%. Can the buyer broker go back to the buyer and say, hey, Mr. Buyer, they're offering me 3%. You're not paying any of this. I could use the extra money. Why don't we just cross out the 2% on our buyer agreement, write in 3, we both initial it, and I can make a little extra money. Sounds great? Wrong. That is not acting as a fiduciary. What that extra 1% on the listing side means is that there is a dollar amount. That 1% is a point. It equates to an actual dollar amount. And that dollar amount should be utilized for the betterment of your buyer, not yourself. So you need to go back to your buyer and say, look, Mr. Buyer client, there is an extra point on the listing side. What do you want to do with that? You can utilize it to better your offer. You can provide it to me because I'm working really hard. We can split it. That's a discussion you have to have with your client. That money does not automatically go into your pocket. Here's the opposite of that. Let's say the listing side is 2%. The buy side is 2%. The listing side is offering 1%. And you say, Mr. Buyer, you know what? You've been diligent. You're working with me. I want to help you. I don't want to take more. Well, guess what? You don't have to. And the parties can again agree to modify the contract. And in that situation, they would take the 2%, cross it out, write in 1%, and the parties would initial it. That's how you modify one of these contracts. You make a written modification and you both acknowledge it, buyer and buyer agent. That simple. So in the past, cooperating compensation was unilaterally offered and unconditionally offered through the MLS. And whatever was written on the MLS, you could guarantee that you could recover those amounts. And if they failed to pay you, then you could take them to arbitration. So now that it's not published on the MLS, we need a document that's going to memorialize and bind, whether it be the listing agent or the seller, to the cooperating agent. So NISAR has created two forms. They have one specifically designed for a listing broker, and they have one specifically designed for the seller, whichever one is offering out the cooperating compensation. They are both very, very similar. So we're going to deal with them both at the same time. So this is the one for the seller. It is offering out cooperating compensation. As you'll see, you have to decide who cooperating compensation is going to. Is it going to the buyer's agent, the sub-agent, or the broker's agent? You then need to identify that compensation is not set by law and what the cooperating amount is. So we've been getting a lot of questions as to, well, when do we use this? And the best practice is a buyer's agent, once they learn of where the cooperating compensation is coming from, should fill out this form partially and send it over with your offer. So let's say, for example, your client wants to make an offer of $1 million on a property that's worth $1 million. You have confirmed that they're offering out 2% cooperating compensation to the buyer's agent. You would take this form, you would check off buyer's agent, you would initial it where you understand that it's not set by law, and you would put in the amount 2%. You would then send it over with your offer. If your offer is accepted, the seller, or as the case may be, the listing agent, will then memorialize saying, yes, we agree. We are going to pay you 2%. And then the proper party, whether it be the seller or the listing agent, will sign that and return it to you. Keep in mind, this doesn't mean you are going to get paid. There are conditions that are written into the cooperating compensation that state that you will only get paid if the property goes to closing with your clients. So HGAR, we have simpler ones as well. We also have one not only for the residential sales, but we have one for rentals as well. This is our cooperating compensation agreement, fully negotiable. Who's getting paid? Buyer agent, sub-agent, broker's agent. Is it going to be paid directly through the seller, or is it going directly through the listing agent? And if so, what is the amount? Again, best practice, partially prepare this, send it over with your offer, whether it's a listing, a purchase offer, or a rental agreement. Therefore, it's in the listing agent's hand, or the seller or landlord's hand, when they decide, yes, they're going to move forward, and they can fill it out and they can return it to you. Again, the same provisions apply here. You cannot collect on this unless you go to a closing with that party. So, in addition to our cooperating compensation, it has to be closed. And there's a line here that says that you are not getting more than what is being provided to you in your buyer agreement. You cannot exceed the cap. So, as I talked before, very quickly, because cooperating compensation was offered out through the MLS, the resolution for disputes when people weren't paid was through our association, through mediation and potential arbitration. Because that does not exist anymore, there is a new provision that goes into great detail as to how dispute resolutions are going to be resolved. They are pretty similar in all ways, shapes, and forms. In NISARs as well as HGARs, it is mandatory mediation. If it can't be resolved in mediation, it is arbitration. It also provides a provision that the parties cannot file a lawsuit, and then they cannot file a class action. One thing that HGAR has done, as in addition, we provided you a memorandum of agreement. This, like all the other forms, is free to utilize, modify, use it however you want. This has price, terms, what's included, what's not included. We put it there for your use. We haven't had one in the past, and in light of the fact that we were doing all these new forms, we thought it would be best for our membership to create a new form for you. So, wrapping it up, here's a quick recap. Cooperating compensation is no longer on the MLS. Seller concession fields have been added. That's a yes/no box, and if you want to write yes, then you can have a choice to put in a dollar amount. You must use the new listing forms or the addendum. However, keep in mind that if you are signing up a new buyer, a new listing, you have to utilize the new listing forms. You can use the NISAR form, you can use an HGAR form, you can have them modified by your attorney, or you can utilize any other form so long as it complies with New York law and the NAR settlement. Again, you are free to modify them. You must use the new buyer agreements, whether they are HGARs, NISARs, or someone else's that is compliant with the settlement and New York law. Again, best practices for cooperating compensation: partially fill out the form, present it with the offer. If the offer is accepted, the seller or the listing broker will fill it out and return it. You will not be paid unless there is a closing with that buyer. So that's everything. I strongly recommend everybody take a look at facts.realtor. Much of the information that I talk about here today is in there with a lot more information that I haven't talked about. You'll see here the website for the NISAR legal forms. Our forms can be found on the HGAR member portal under documents. And again, my email address is brian.levine@hgar.com. That is everything. And at this point in time, Gary, why don't we open it up to some questions?
Certainly, and great presentation, Brian.
Thanks.
Our first question: what is the difference between comp offered directly by the seller versus seller authorized comp offered by the listing agent?
They are pretty much the same thing. It's a conduit through which it is provided. So if a seller is offering cooperating compensation directly to the cooperating broker, then that seller is liable for the failure to make that payment. If it is going through the listing agent, then the listing agent is liable if there is failure to make that payment. So if the seller fails to pay the listing agent, and the listing agent then fails to pay the cooperating broker, they can't turn around and say, oh, well, I'm sorry, I don't have the money, because they're the ones that are bound by the contract.
Thank you. Can a listing office, not the agent, set a minimum percentage that they will accept as compensation for a sale?
Yes. And the reality is this: compensation is fully negotiable, but that doesn't mean you have to take less than what you have valued. So you are free to negotiate that. And if you cannot come to a meeting of the minds, then that listing buyer, that listing homeowner, landlord, or that buyer can walk away.
If a buyer calls me directly on a listing, not an open house, can I show them as a customer, or they need to sign the buyer agreement before I show them the property?
The fact that they are contacting you with regard to your listing, that is acknowledgement that you represent the seller. That means your fiduciary duties are to the seller. That means that the buyer is unrepresented. You are free to show that buyer your client's property, and you are not required to have a written buyer agreement.
Great, thank you. Is the Department of State's standard operating procedures requirement still in effect, where brokerages are allowed to offer all buyer exclusive agreements or none, but you can't do it in combination?
Right. So SOPs are still in effect. And if you recall, the SOPs relate to, is the brokerage going to require everyone in their office to utilize exclusive buyer agreements? A brokerage is free to say yes to that, which would require everybody in their office to utilize exclusive buyer agreements, or it can be no. They're not requiring exclusive buyer agreements. But what the settlement says is that there has to be a buyer agreement. That can be either exclusive or non-exclusive. It can be one or the other. So you can still satisfy the SOP with regard to the exclusive nature of a buyer agreement, but also satisfy the NAR settlement agreement of having a writing.
Great. So HGAR's stance is not have the seller's potential cooperating brokers commission in writing anywhere?
Correct. The decision was made for liability reasons that if the seller wants to offer out cooperating compensation, they are free to do so. Our forms don't provide it, so you're going to need to memorialize it somewhere else. A letter, a memo, both of you sign it. You can have your attorney write up something. It's very simple with regard to cooperating compensation and what they're going to be offering out, but we do not provide it on our forms.
Thank you. If buyer states not willing to sign unless they are not obligated to compensate, and there is a seller offered seller offered compensation, what is to be done?
Well, if a buyer agent doesn't want to sign, then you can't take them to a property, number one. Number two, it's not your client because they haven't signed anything. So you don't have a written buyer agreement with them. So whether they're offering cooperating compensation or not is a moot point. However, if I kind of drill down on this issue, a buyer can agree with a buyer broker to take zero compensation. If an agent wants us to work for free, they're more than welcome to make this a hobby and not a business. However, as a buyer's agent, you need to identify a specific amount in there. And whether that is 0 or $1 or $100 or 2% or 5%, it has to be in there. And that's what the rules require.
Great. Do we have to get an agreement signed when an unrepresented buyer calls us, the listing agent, to show one of our own listings?
Again, the answer is no, because they are an unrepresented buyer. You represent the seller. They're calling on your listing. So therefore, they are a customer. You are free to take them. It doesn't satisfy one of the two tenets. You are not working with a buyer, although they want to tour a property. So therefore, the written buyer agreement is not required.
Great. At what point does the release from buyer agency to dual agency kick in? At the appointment, at the offer, or at the meeting of the minds?
According to NAR, you cannot have dual agency unless you have a pre-existing relationship with both parties. So if a buyer walks into your open house and says, I want you to represent me, you can't do that because you need consent from both parties and you need a pre-existing relationship. So first and foremost, you can't enter dual agency with that buyer. So what can you do? Well, you can show them the property as a customer, and you can free to show them property. And when they say yes or no to that property, if they want to see more properties, you can then establish a relationship with them of broker-buyer relationship, sign them up, begin showing them other properties. Now that you've established that relationship, in the event that they want to come back to that property, now there's an opportunity to enter into dual agency because you've been representing them as a buyer. You've been representing the seller. You now have dual agency, and you can then sign them up for dual agency. General rule of thumb is true dual agency kicks in when that buyer looks to make an offer on the property.
Great. It seems buyer brokers are now making their buyer's offer contingent on compensation from the seller to themselves, without the acknowledgement and approval of their own buyer client. How do we avoid this? Is it
You're gonna have to read that one again for me, Gary.
No problem. It seems buyer brokers are now making their buyer's offer contingent on compensation from the seller to themselves, without the acknowledgement and approval of their own buyer client. How do we avoid this? Is it deceptive to the buyer?
Oh, it's very deceitful. It's criminal. Buyer agents can't walk around saying, all right, the offer is $500,000 plus 2%. That's against the law. They could subject themselves to criminal action, subject themselves to Department of State violations, Code of Ethics violations. So if they're not authorized to make a request for cooperating compensation or inquire about seller concessions, they cannot do it.
Gotcha. Thank you. compensation document should be sent separately from offer, or can it be an additional document attached at the same email of the offer to purchase?
It's fine to put it together. I think the best practice is you want to make the transaction as seamless as possible. So if you've confirmed that they're offering out cooperating compensation, whether it's coming from the seller or it's coming from the listing agent, you've already had that information. Fill it out, sign it. So when the offer goes over, if they want to agree to it, the documents are right there in front of them. That makes everybody's job a lot easier. And now you're not chasing down documents. So I would say send it over with the same email.
Great. Please explain how it works when the listing broker is to negotiate and pay out compensation to the buyer's broker.
It's the same way it's always been done. Listing broker pays out compensation to the buyer broker. So the listing broker is authorized through whatever negotiation he's had with the seller to pay whatever X percentage it is. That money gets funneled through the listing broker, and that listing broker writes a check over to the cooperating broker. It's what we've been doing for the last how many years?
Exactly. Can we use a combination of both HGAR and NISAR agreements on the same transaction?
You can use any forms you want.
Great. NAR said all buyers must sign some type of buyer's agreement before an agent can open the door to a property, even if I'm showing my exclusive right to sell listing.
Again, I guess that goes back to, yeah, you have to have a buyer agreement, but who's walking through the door? If it's a buyer that you don't know, they are unrepresented, and you're free to show them the property because of the simple fact that you don't represent the buyer, you represent the seller. So you don't need a buyer agreement. There's two keys to this. Remember, have to be touring a property. You have to be working for the buyer. When someone asks about your property, when someone asks about your listing, you are not working for that person.
Understood. What happens if the listing agent / seller refuses to sign the seller compensation agreement?
Well, that's going to be a problem because now you're not, the parties aren't bound. So what would result if the seller refuses to sign the exclusive, the cooperating compensation agreement? That would mean that the buyer is on the hook for whatever that money was. And the buyer's not going to like that, right? Because now that buyer has to pay that amount. So that might certainly stall the transaction because part of the agreement was pay for the house, you pay for my buyer compensation. If they're not going to do that, well, now your deal is going to blow up.
Next question is, you said that if sellers are offering compensation to a buyer's agent and it is more than what is agreed upon in the buyer's agreement, you said you must tell your buyer about it, refuse the extra money, or another option is to share the extra money with the buyer. How would that be done?
So the important part of that fact pattern is don't assume that if there's extra compensation coming from the listing side, that you are entitled to it. You are not entitled to it. You have indicated to your client that you're not going to take anything more than what you've agreed to on that buyer agreement. So that extra money needs to be brought back and discussed with your client as to how you're going to disperse that. Is it going to be you, the agent, are going to keep it all? That the buyer is going to utilize it as part of their negotiation? Or you're going to split it? Those are the only three possibilities that could happen. In whatever fact pattern, let's take the buyer is going to utilize it all. Your contract stays the same, nothing changes. You are still capped at what you're capped at. You collect what you collect, and that extra money is utilized for the buyer. However, if you are allowed to keep the entire amount or you share that amount, you need to modify your contract. You can't void the contract because under the NAR rules, you still need a contract, but you can modify the terms. So what would you do? You would take that percentage of what it was, cross it out. You would then put in what it's going to be, whatever that increase is, and then both parties initial it. Therefore, you have a written modification that has been approved by both parties.
Great. I'm not sure that I understand the dual agency cooperation. As a dual agent, we can only get paid on both sides of representation when we sign the forms with the seller prior, correct?
Correct.
Yes.
Maybe I should elaborate on that. Want me to elaborate on that a little bit?
Sure.
All right. So real quickly, remember, dual agency, you can only collect. There's two things that are happening here. Number one, dual agency. That means cooperating compensation is not shared with the buyer side. So that means you can only collect from the seller side. If dual agency has been adjusted on that listing side, the parties, the buyer agent and the listing agent, will share that amount. If it isn't, then that original amount would be shared amongst the parties. And that would be obviously far less than what you would normally get. So that's the first part of it. The second part is with cooperating compensation, you can't share it, and you cannot request on the buyer's side for more money if it hasn't been already negotiated. Because remember, the broker is in conflict. The broker can't turn around and go to his client and say, oh, hey, by the way, situation has changed. You need to pay me more money. That's not in the fiduciary interests of your client. So you can't turn around and ask for more money.
Gotcha. Thank you very much. Can the listing agent ask to see a buyer's agreement before they approve your appointment?
No. It's just like a buyer doesn't have to see your listing agreements before he tours a house.
I thought that rentals hadn't changed. So why is there a new form?
The reason there's a new form is because the MLS has changed. MLS no longer puts cooperating compensation. So number one, we had to make the modifications that doesn't go on the MLS. Number two, in light of the fact that we were seeing this litigation relating to residential sales, it's just a matter of time before someone files a lawsuit that says you're colluding and you are violating the law, antitrust acts with regard to rentals. So we're going to get ahead of the game, and we're going to make rentals a part of it as well.
Thank you. If a buyer signs an agency disclosure allowing advance consent of dual agency, is that enough to keep the contract in effect in the event of dual agency?
What advanced informed consent gives you, it gives you the authority to show a client a property. So in the situation where you sign up a listing, you have a listing, but you don't have a buyer at that point in time, but you do the advanced informed consent for the purposes of saying to your listing, your homeowner, look, Mr. Homeowner, I'm sure you want to get as many buyers as possible. So by checking off advanced informed consent, whether it be dual agency and designated dual agency, that allows me, number one, for me to bring my buyers. And number two, it allows me to have my broker bring their buyers. You are giving me informed consent to bring those people. That doesn't mean that you are in dual agency. You've gotten informed consent to participate in potential dual agency. You get into dual agency when you actually have a situation where you have a buyer and a seller, and one's making an offer to the other. Now you are an actual dual agency.
Thank you very much. Another question. Aren't more buyers going to go directly to the listing agent and not have to enter into a buyer's agreement? Isn't this a way for them to not pay a buyer's agent?
They could. I don't know if that's going to be the trend. Remember, if they go directly to the seller, there's an issue of there's no cooperating compensation, and their fiduciary duties are split. You know, you cannot be a true fiduciary in dual agency. So that means the agent represents the seller and the buyer at the same time. They have a choice. They can have their own representation.
Perfect. If I have a customer buyer, not a client buyer, do I have to have the customer buyer fill out the buyer compensation agreement?
No, because they're a customer. They are not your client.
Perfect. So open house, buyer walks into an open house, wants to make an offer. Can you still get compensated if you do dual agency with a designated agent?
So that's how it would operate. Well, the question becomes, buyer shows up at an open house. Have you represented the buyer before? If the answer is no, then you're not entering into dual agency because you need to have that pre-existing relationship. If the buyer shows up, makes an offer on the house, and it's accepted, there's no dual agency, but you're going to get that commission on the listing side. And if you filled out that provision that says if it's dual agency, designated dual agency, or an unrepresented buyer, you will get an increased compensation. It's so long as that was negotiated when you listed the property.
Thank you. What if a buyer contacts an agent to show a property that is not their listing? Then a buyer agreement must be signed before the showing?
If a buyer agent contacts you and says, I want to see properties, whether it be one property, two properties, 10 properties, a variety, you need that listing, that buyer agreement.
Perfect. What if the buyer doesn't have the funds to pay your fee of 2% and asks you to submit offers to include the 2%? Can this be done? And if so, where can we indicate this?
That will be done in your purchase offer. So your memo. So we provide a memo, and what you would say is, and this is kind of how this may play out over the next couple of years. Buyers are strapped. We all know that. It's hard enough coming up with a down payment when the average property in Westchester County is $1 million. So they got to come up with a down payment, and they got to pay their agent. So they're required to enter into a buyer agreement, and they're going to say, all right, well, I'm going to pay you. I think the was 2%, they said. So I'm going to pay you 2%. So they can do a couple things. They can say, just show me houses where there's cooperating compensation being offered out of 2%. Or, that's I'm going to pay that 2%. And that's how it's going to work out.
If a customer buyer, not a client buyer, not a client
Easy for you to say.
Do I have to have the customer buyer fill out the buyer compensation agreement? We just answered that.
Well, the answer is no, because there's no compensation coming over to the other side as cooperating compensation, because you're not representing the buyer.
Exactly. We used to be able to tell the seller we would get X percentage and a different lower percentage if it is a direct deal. How can we do this now?
I don't know if you can. I mean, if you're establishing what your compensation is now, and again, I'm just going to throw out numbers. Don't rely upon these numbers. Let's say you are getting 2%, 3% for listing the property. If you go into dual agency, are you going to want to take less than 2 or 3%? Or are you going to want to take more than 2 or 3%? If you want to take more, you have to write it in there. Now, if you compare that to what is being offered out as cooperating compensation, that might be beneficial to the seller because, again, let's use this fact pattern. Listing side's taking 2%. You say, if it's dual agency, I will take 3%. Okay, Mr. Seller, if you offer out cooperating compensation, you're going to offer out 2%. So at the end of the day, if it's an in-house deal, it's 3%. If it goes outside, it's 4%.
Understood. And what if the buyer's not offering to pay anything?
Well, you want to work for free, I guess is the question. If you're willing to work for free and make this a hobby, you're more than welcome to take that buyer out and show them properties for 0%.
So I think we are at time.
Yep.
But I want to thank everyone for attending, and thank you, Brian, for an excellent presentation.
Yep. Pleasure is mine, everybody. Thank you very much. Again, keep in mind, email address, brian.levine@hgar.com. Check out facts.realtor and check out those sites that I pointed out earlier. Thanks a lot, everybody.